Good afternoon, and welcome to HealthSystemCIO.com All-Stars Panel Legal Briefing, a complimentary webinar and tweet chat from HealthSystemCIO.com. Little housekeeping before we get started. My name is Anthony Guerra. I'm the Editor-in-Chief of HealthSystemCIO.com, and I will be your webinar moderator today. For the first time today, and going forward, we're going to be having an accompanying tweet chat hosted by Kate Gamble, our Managing Editor and Director of Social Media, where you can engage in a dialogue about what you're hearing and your thoughts on the issues, any questions you may have. You can do that. All you have to do is use the hashtag HSCIO legal, and we'll be peeking over at that when Kate lets us know something's interesting is happening. So she will be hosting that and putting up tweets during the event, so you can feel free to open a screen on Twitter and get involved. You can ask a question if you want to. You can do that over on Twitter, or you can do it through our Q&A box in your WebEx console. Leave the default set to all panelists and send those in as they occur to you, and we'll pose those later in the program. You can download the deck using the URL on your screen. We've also got a shortened URL at the bottom of all slides, along with our tweet chat hashtag. And we are recording today's event. It will be posted to our YouTube channel within 2 days, if not sooner. You'll get an email when it's ready. Just so you see how we're going to spend our time today, we're going to do about a half hour, 35 minutes on our main panel discussion with Helen Oseslowski, Healthcare Attorney and Principal with Oseslowski LLC, and Steve Fox, Principal with Post and Shell. You'll be able to see our speakers' bios as they're speaking. I'll put those up for you. So let's jump right into it. Steve, let's start off with you. Can you give us a brief overview of your organization?
Sure. Post and Shell is it's a law firm. We've got about 150 lawyers in 7 offices throughout the Mid-Atlantic, basically in Pennsylvania, New Jersey, and I'm in Washington, D.C.
Okay, excellent. Helen?
Thanks, Anthony. Oseslowski LLC is a boutique firm located in Princeton, New Jersey, established in 2010. It is focused on HIT, HIE, privacy, and all things related to data. We've been servicing our clients since 2010 and have a lot of experience in the data and privacy and HIT field. So.
Excellent. All right. Let's jump right in, and we're going to go with Steve first. Steve, you want to list the top 2 or 3 areas where health systems, and specifically health system CIOs, are currently getting into trouble. By trouble, I mean murky areas where insufficient or ill-informed legal advice can get you into hot water.
Sure. I guess there are 2 things that came to mind when I saw that question. One is something I've been talking about for years, and you still see people failing to do this all the time, and that is failing to make sure that all mobile and other devices are encrypted. Both Helen and I are going to talk briefly later about the problem when you don't have that, because I would say, and Helen, I don't know if you've seen this too, but virtually every data breach that you read about on, for instance, on OCR's Wall of Shame, virtually every one is caused by somebody leaving a device that was not encrypted, because if it was encrypted, we wouldn't even know about it. I mean, that's the beauty of doing that. It's, you know, it's a simple procedure that people can do. I mean, there is an expense to it, and it's, you know, it's not, I mean, it's something that takes some time and labor and money, but once you do that, if the person then leaves their, you know, their iPad or their laptop or their hard drive or their thumb drive in, you know, on the subway, we'll never know about it, because nobody who finds that is going to be able to do anything. So that's certainly one thing that I see that people can sort of easily cure. The other thing that I see that I wouldn't say I fight with my clients about it, but we have a disagreement, and that is I see problems when people are entering into contracts that are what I would call long-term contracts. That is, anything beyond, to me, maybe 5 to 7 years. I think 7 years is a long time, but it just seems to me, in the, you know, the way technology is today, I mean, everything we use right now was practically not even around, 5 or 7 years ago. So when you sign up with a long-term contract with, whoever it is, whether it's Epic or McKesson or, Cerner, Siemens, of course, now Cerner bought Siemens last year, and Siemens was always, I was always sort of knocking heads with them because they like the longer the better, and from their point of view, from the vendor's point of view, I can understand it because that's a long-term cash cow that they've got money coming in for a long period of time. But the problems that I see with these long-term contracts is, let's say you do a deal today with, and I'm not picking on Cerner, I'll just use them as an example. Let's say you do a long-term deal with Cerner today. How do you know, 10 years from now that Cerner is going to be the same preeminent, vendor that they are today? Maybe they're not. Maybe they're going to have a change of, leadership, and, all kinds of things can change. Also, and this is something I've seen a lot happen when clients call me after the fact, and they say, can you help us get out of this contract? Because what happens is the people who entered into the contract are now gone. A new CEO or CIO or CFO comes into the picture and says, you know what, I want to get rid of Siemens or Epic or whoever it is and go to somebody else. And somebody's got to tell them, well, wait a minute, we've got another 8 years, at $5 million a year to, for this contract, we can't do anything. And I've also seen it where that has actually caused mergers to fall through because the merger partner took a look at it and said, well, we want to buy this hospital or this health system, but we're not going to be saddled with a contract that runs for, another 7 years. So those are the two things that I would say that my pet peeves, I guess.
Excellent. Helen?
Yeah, I want to echo that last point Steve made. I was actually similarly involved where the merger went through and trying to get out where there's two systems who have, two different platforms and there's agreements, and not having an out is extremely problematic. You can end up with having to make a huge payment to get out of that contract. And so the time frames, but along those lines, but on a slightly different point, I wanted to make a point regarding, trusting your BA or your vendor too much. I see a lot of times is you get into the service contracts and for CEOs or CIOs focus on, what they need from a purely technological standpoint, in terms of the services they need. But underlying that, the need to manipulate data and the variety and the foresight in the future to know and to anticipate what you might need out of that vendor and whether or not they can or cannot deliver it. Is something that I think CIOs need to think about, quicker in the negotiation process rather than getting either stuck in a contract that ties their hands down the line. I see a lot of times they're like, oh, well, we have a BAA, we'll attach a BAA to place, and that covers it. The BAA on its own doesn't cover anything. You really need to get to the specifics because a lot of times there's an education process that goes along with the vendors who are BAAs, in addition to, the security practices and what actually is expected to them, depending on, what you're expecting to do. Are you going to network with other people and other providers in the community? Are you going to have interfaces? Is data going to be able to potentially flow out of the system and out of the vendor? And understanding how data flows from the beginning, how you want it to flow, and making sure that that gets all baked into your BAA with specificity. Because what I see, when it's not done in the front end, in the back end, there's a lot of trouble with trying to get what you need, or then your hands are tied and not being able to free up the data and use it in the way that you need for things like ACO and other kinds of purposes, which we'll talk a little bit further in the presentation.
Excellent. Excellent. Appreciate that answer. Steve, let's go over to you. We'll talk about probably one of the biggest thing in the news. Ransomware is on the rise. Anything a health system or CI can do from a legal or insurance point of view to put them in a better position to recover from an attack. Any advice on what they should do in the event of an attack?
Well, you're right. This is in the news because right in my area, in the D.C., Maryland area, we just within the last couple of weeks had a huge ransomware attack on MedStar, which is one of the top, say 3 healthcare organizations in the D.C., Maryland area. And I'll talk a little bit about exactly what happened there. But yesterday I was able to get to a guy who I met at a conference last year, who's the Chief Information Security Officer of a major academic medical institution. He asked me not to specifically use his name, but I asked him about sort of what kinds of things he does, or what he sees as this. And one of the things he said is that this is something that's going to be around for a long time. He said his organization has at least 3 or 4 times a week they get hit with this. I was on a panel with him last year, and I asked him what kind of things he does. And you mentioned insurance. He said, make sure you're insured, because that is sort of about one of the only things you can be sure of that that is going to protect you in this. Because no matter what kinds of precautions you take, the people who engineer these attacks seem to always be one step ahead. And so he said, always make sure you have plenty of cyber insurance. And that is an area that I think I see a lot of clients who don't have that, and who don't require their vendors. I mean, so you were mentioning legally what you can do. So one of the things we always do is put in contracts with the vendors a requirement, first of all, for minimum insurance, for coverages for a lot of different things. And one of those, which we started to do several years ago, was also ask the vendor to make sure they had cyber insurance, and depending on the size of the deal, we specify what the minimum amounts necessary for that. And you should also look into the insurance companies, because some insurance companies are not necessarily the same quality as others, and so you want to look at that. But so and I feel like I should just give some of the things that he said that are not necessarily legal, but I think that they might be useful for our listening audience. One of the things he said was always use multi-factor authorization or authentication for administrators, so that even if somebody, if a hacker gets somebody's password, if they don't have the multi-factor authentication, that their phone or whatever it is, that a little RSA device, then they're not going to be able to get in there. Another one that's not legal, but it's something I recommend to our clients all the time, is sort of internal anti-phishing campaigns, and that is where you're sending out an email that is designed to catch people who who shouldn't click on it, and then when they do, but then you can use that as an educational training kind of thing and say, look, you shouldn't have done that, and this is why, and you use that as an opportunity to get training. On the MedStar deal, this person doesn't work for MedStar, but he said he talked to people who did, and what was interesting about it is he said that was an example of something where it didn't involve training. I was involved in a phishing kind of situation for a client about 2 years ago, and that was the classic phishing thing where some people sent out an email to everybody in this organization, and all it took is one person and one receptionist for the psychiatry department happened to click on it, and it said, this is from IT, we need to confirm your username and password. And of course, that's the classic phishing thing. This woman unfortunately gave that, and they were able to get in. But in the MedStar case, that's not what happened. It was there was a problem with servers that has apparently been known with Java, using Java, and they were it was one of these attacks where people are simply sort of exploring the internet and just trying to look for this problem. When they found it, they got in. So no amount of user education really would have prevented that. But what you do in that case is make sure you have backups, and if you have backups, And from what I understand, MedStar did not pay anything to these people because they simply shut down their system, which was significant, for a week, and were able to then use a backup. But that can cause a lot of problems. And in terms of, as far as what legally you can do, we're really not talking about this, I guess, in this talk, but I just going to mention real quick, and that is the limitation of liability contractually is so important when organizations are doing contracts with their vendors. And the limitation of liability, if, for instance, it was the vendor's fault that this happened, you want to have the right under the limitation of liability to make sure that the vendor is responsible for any damages it causes, because typically all of the kind of damages that would be incurred by the hospital or the health system would be indirect damages, which are typically excluded from a limitation of liability. So I just do want to mention that, that's an area that you really want to look closely at when you're doing your contract.
Excellent. Very good. Okay, let's talk a little bit about patient engagement. Helen, why don't you take this one? Any legal advice to CIOs and health systems looking to get that interaction and engagement with their patients?
Yeah, absolutely. We know this is a huge component of meaningful use, as well as other government programs making a push for patient engagement and getting individuals and patients more involved in their own care. For the CIO's perspective, and I think the top two things to bear in mind are when you are deploying these kinds of programs, getting patients involved, you need to bear in mind, number one, the security, and number two, the processes that you have in place to verify who you're actually engaging with. So let me talk a little bit about the security piece of it. The most common mechanisms used for patient engagement are applications such as patient portals that are somehow interfaced or tied to the main HIE or HIT platform. Those portals, would typically, need to be secure, ideally through encryption. Some overlay or import direct messaging, which would be, fall into the encrypted category. But just like with any other communication, once you deploy something where the PHI, it always is PHI, and I guess that's an overriding or a starting point just for CIOs to understand that, just because the patient has engaged the system and it's between the system and the patient, and they're so to speak, implicitly or expressly authorizing it, you are exchanging and disclosing PHI, and you are, as the healthcare system, responsible to a large extent, especially if you are providing the mechanism for those kinds of interactions and release of PHI through portals or otherwise, are responsible for the security around how that interaction and how that discussion takes place. So along those lines, you want to make sure, going back to your HIT vendor, getting back to my earlier point, if you're anticipating these kinds, or if you're adding on this service line as a new service line to your HIT contracts, you make sure that you have thought through thoroughly exactly how your use cases are going to look. Are you going to use a patient portal? Are you going to use direct as a messaging application, or some other mechanism for that engagement, and making sure your vendor is appropriately or sufficiently able to support your security standards to the standards of the healthcare system, not necessarily the standards of the vendor, to the standards that the healthcare system wants for those kinds of interactions. Just a note here, if you are using, and I have seen uses that are less formal for patient engagement, i.e. email, text, obviously a lot more risky if you're deploying or using those kinds of, I shouldn't say a lot more, just risky, period. Email on occasion, email as a blanket general principle should not be used to communicate with patients if other means can be deployed, and you should always push to use more secure and encrypted means to engage patients for those kinds of interactions, and also for providing them with any kind of patient data. I will mention, however, that HHS is so supportive of patients receiving and having access to their health information, that if the healthcare system has no other means to be able to communicate with the patient, HHS basically said in preambles and in other guidance documents that they would not outright prohibit the use of email. It's just that, and if the patient wants that email to be used, they just simply recommended that the patient be informed upfront of the risks of using email for transmitting any kind of data, and ideally, acknowledge that or sign that. Now, just bear in mind that if you do go down that route and accept the patient's desire or preference to use email, that of course puts you at risk. If there is a breach, is it he said, she said, whose fault exactly was it? Was it your fault, the healthcare system, in the way that you transmitted the email, or was the breach something that occurred after the fact once the patient received the information on her or his end? It's really sometimes hard to distinguish or pinpoint the time at which the breach occurred, and so you can get yourself into a bit of trouble there. Going back then to make sure that the patient is fully informed of the risks, and a lot of times systems are putting out some sort of acknowledgement and acceptance of risk by the patient with those kinds of emails. And then real quickly about verification along those lines. Just making sure that the CIOs take some time to put in some process of verifying the identity. A lot of times the banking industry is alluded to making sure that you have not only appropriate access credentials that are assigned that are unique to the individual, so that systems can't be hacked and access can't be gained to all data by people who are not supposed to be, who pretend to be, or are standing in the shoes or pretending that they are a patient. Making sure you have a verification process. Just simply sending an email and having them, sign up is really, quite frankly, not enough. There has to be a second verification step of some sort to make sure that the person setting up the account is exactly who he or she says they are. So that's kind of what I don't know if Steve has anything to add to that, but.
I'll tell you, the only thing I would add is I think the biggest, what I'm looking forward to is, as far as a technological breakthrough, is a better way to send encrypted email, because that to me is really the hardest thing. Because even just from my own perspective, we have encrypted email, but I would say if 1% of our clients use it, I would be surprised, because it's so cumbersome and awkward to use, because then, and I get it occasionally from clients who use it, and you've got to have, if I've got 10 clients who use it, they each have a different system. You have to sign up and have passwords, and so until encrypted email gets easier, I just don't see that as sort of an option for most people, because I think most patients find it too difficult. I think the patient portal is a lot better if you can, and I see more and more clients are going for that.
Very good. Very good chat. Okay, next question. Steve, let's go for you on this one. Information exchange. Health systems must share information with caregivers at other organizations. Any advice on how they can do this and stay out of trouble?
Well, I've been involved in a number of health information exchanges, and it's tough because I don't know what, Helen, what you found, but a lot of organizations historically have not been very happy about the idea of sharing information, even though it's clearly good for patients and it's good for patient care, but especially when you've got a, depending on the market that, or the city or the town or whatever it is, especially when you're sharing information with competitors, I see a lot of hospitals that are just, very slow to adopt this. But it is a fact of life, and it's becoming more accepted. But I think the biggest problem is that, when I've been involved with HIEs, I've seen the biggest problems are really not technical or legal. They are political and, jurisdictional and even personal, in terms of just getting, you have all the people in the room, and I was involved in one years ago in Maryland. It was actually the first HIE in Maryland, and I think it didn't pay for the guy whose brainchild it was. It sort of doesn't pay to be too far ahead of your time, because he got every major player, every hospital and health system and in the room, but, you know, when you have MedStar and Johns Hopkins, and just using examples, and University of Maryland, who are all big systems and all competing with each other, they don't necessarily play well together. So I've seen this as an issue more, you know, as I say, more political than technical, but I don't, that's about all you know, and I think as far as from the legal standpoint, the hardest, and that's what makes it hard to draft the documents that are going to govern how these organizations are going to have to work together. And you know, it takes some time and patience, and getting people to sort of put their egos aside and try to work together to get something done.
Yeah, I mean, I'll chime in on this because this is, you know, kind of my daily existence, health information exchange, and Steve's exactly right. You know, honestly, your question, you know, health systems must share with caregivers, you know, for reasons that benefit the patient. How they do this in the right way, it really starts first with the buy-in of the organizations who are involved in the health information exchange. If they come to the table from the position of creating barriers and going beyond appropriate concerns and just simply resisting for the sake of resisting for business, political, or other reasons, it's just not going to work. So you definitely need to have, from the get-go, that buy-in. I've found that the most healthy and productive and successful exchanges result from a balance of healthy, maybe skepticism has a little bit of a negative connotation, but coming to the table with the appropriate concerns regarding privacy and security, making sure that we don't just rubber stamp and let the data fly, understanding the parameters under which information can be supported for exchange under federal laws, whether that's HIPAA, whether that's Part 2, 42 CFR Part 2, and then, of course, taking a look at the state laws and understanding that there actually are, truly understanding your state laws. The knee-jerk reaction often is that the state laws prohibit the sharing of sensitive information, period. And that's kind of been built into the urban legend and kind of the telephone game and the he said, she said, and it kind of has crept, and all of a sudden it becomes, you know, what everybody believes it is. But upon closer inspection of state laws, you actually begin in analyzing a state law, you begin to see that there are, quite frankly, a lot of exceptions, and the most common one, even under state statutes such as protecting HIV/AIDS information, it allows for the sharing of HIV/AIDS information among and between two or more healthcare providers that are in the active treatment relationship with that patient. And people and organizations are, quite frankly, sometimes surprised to hear that. So to answer your question, you know, it's coming in with the, you know, around the table in health information exchange with the organizations, with a commitment to understanding how to make this work for the benefit of the patient, and then having a healthy understanding of both federal and state laws and a true grasp of what are true barriers, what are not true legal barriers, and then, you know, what is the, you know, what is the outside of the legal barriers, what are the other kinds of risks that we are willing to tolerate or not willing to tolerate, and what can we do in terms of safeguards technologically or otherwise to prevent breaches and things from happening, even though the information exchange can occur. I just want to end that point with also saying that about this time last year, in April 2015, that there was a report issued to Congress on health information blocking, you know, kind of springboarding off of Steve's point on that. And that report essentially found and called out organizations and certain types of vendors specifically that were blocking the exchange of information, not for appropriate reasons, legal barriers, whether those be privacy laws or otherwise, but for other reasons, whether that be trying to retain business to themselves solely, and so where we're refusing to share information because that would mean giving up some of their business, or for other reasons. And they you know, scolded, if not, and called those organizations out and saying, you know, those are not legitimate reasons the people who are really suffering or are being hurt in those kinds of positions are the patients. So if you have a chance, that's listed on the website on ONC, the Office of National Coordinator for Health Information Technology. The report was posted April 2015, has some really great stuff there about information blocking and how that's not appropriate. So the end point here is if it's legally appropriate, everybody gets around the table to make it happen. There are many ways that you can exchange information within the confines of the law and for the benefit of the patient.
All right, very good. Steve, let's start with you on this. Let's talk a little bit about BAAs. Everyone needs a little help, which means business associates. What advice can you give around establishing solid BAAs?
First, I would say try to use your own, and I'm speaking to healthcare providers because the vendors do try to use their own. So I'm saying try to use your own, get a form that you are happy with, that obviously complies with the law, and use that. And when the vendor says, well, we like to use ours, you say, well, we like to use ours. And I mean, it's always a fight, but still, it makes sense because the vendor is more able financially. They have a lot of in-house lawyers usually. They're able to modify or to review yours rather than waste time trying to use theirs. And the vendor's BAA is going to be bare bones. It's going to comply typically with HIPAA, but it's not going to have anything extra. I think there's just a few more points I want to make about BAA, and that is there are going to be a lot of interesting developments because just last month in March, OCR began sending out letters to I don't know how many, but probably hundreds or thousands, where they're going to be starting a new round of audits. This was the first step in where they're going to be gauging compliance with HIPAA. And they've sent out all these letters where they're just initially asking for sort of a survey, different information, but they're going to be drilling down and looking to see, if there's widespread compliance. And this relates to what happened in 2013, where the HITECH Act expanded most of HIPAA's requirements, where for the first time HIPAA then applied directly to business associates. Of course, before that, HIPAA sort of applied indirectly, just by contract to the business associates. But now, for the most part, it applies to them. And I don't know if you've seen this, Helen, but I still see some business associates who don't seem to realize that it really does apply to them directly. And
absolutely,
there's been an ongoing education process. And also, you've got to be concerned about the fact that a breach by a business associate, in many ways is the same as if, it's by the covered entity, because the public and the patients and even OCR is not necessarily going to distinguish between the business associate. And so you want to have language in that business associate agreement that, and it's not required, and a lot of vendors say, well, we don't have to have that in, and they don't, but you want indemnificational provisions, for instance, so that if the breach is caused by the business associate, that they are going to pay for any damages that you suffer from that. So, sort of in addition to whatever the minimum requirements that HIPAA requires, you also want to have some additional terms. For instance, a provision that says that the BA will comply with all present and future HIPAA regulations. The indemnification, which is really important. I mentioned before about insurance. This is a place, too, that you want to make sure that does the business associate have minimum insurance and have cyber liability? And, if there's a breach, are they going to be financially able to pay for the cost of a breach notification? Breach notification is far more expensive than I think a lot of people realize, and a single breach notification incident can cost hundreds of thousands of dollars or more. So it's a very expensive thing, and you really want to make sure that you and the BA has insurance. You want to make sure there's a provision in there that the BA is required to train its staff on policies and procedures. And one of the things that you want to ask is to see the policies and procedures that the BA has. And when you ask for that, in many cases, you'll get a blank look because the business associate doesn't have any policies and procedures, which it is required to have. And the last thing I would say is that you want a provision in the BAA where the BA has to notify the covered entity in the event of any kind of a breach, a subpoena, discovery request, anything at all that you might want to be aware of.
Very good. Helen, you want to touch on BAAs?
Yes. Yeah, I just wanted to add on that last point because I have run into a couple of instances on the breach notification piece. I've had, somewhat that, they don't have to notify the covered entity of the breach if they go through their own breach risk assessment and determine that, once they've gone through the assessment, that it's not a breach that they need to report to the covered entity. Of course, the covered entity ultimately has the obligation to, in turn, report that to patients if they determine that it is a reportable breach. While I think that the interpretation is not necessarily completely wrong, I think that in my opinion, and I'd be interested to hear what Steve thinks about this, it is not a desirable one to go by. Because at the end of the day, there's a couple of things that could happen. Number one, they could simply get it wrong. Number two, the covered entity, having gone through the same analysis, can simply disagree with the breach analysis that the business associate went through, and then ultimately, obviously, it's your data, the healthcare system's data, and so from a falling out, from a public perception perspective, the final fallout and the media blitz and everything is going to fall at your doorstep, at your feet, so to speak. So I've always recommended that the provisions in the BA regarding notice simply mandate that if there is a security incident, and in fact the security rule does have a small breach notification, what I call a subset of security incidents, that you're supposed to report any security incident, you being the BAA, to the covered entity, irregardless of whether or not you've gone through a breach analysis. We want to reserve the right to at least review that at a minimum and ideally to make the ultimate determination of whether it's something we want to or need to report to the patient and or OCR.
That's really a good point. I'm really glad you mentioned that because that is an issue, and I agree completely that it's absolutely essential that the covered entity know about it. And if they agree, fine. But if they don't agree, then they're not going to be bound. They can't be bound by the DA's determination, oh, don't worry about this. Our lawyer says it's not a breach. So that is really important. And it raises a lot of questions because sometimes when negotiating like a remote hosting situation, and we have a provision that says they have to notify us of any security incidents, they say, the vendor says, well, we'd be notifying you like 100 times a day because, we constantly have security incidents where people are trying to, get in our system. So you have to work it out, but there needs to be some kind of a fair, compromise on that. And I'm glad you brought that up, Helen. That was a really good point.
All right, very good. Helen, let's go with you on this one. Value-based care and ACOs, any thoughts here on common pitfalls or things to avoid?
Yeah, this obviously can be a 5-hour discussion, the complexities of ACOs and all the potential pitfalls. So I'm just going to basically throw out the theme of everybody on the call to bear in mind. When you get into these complex arrangements and you have multiple parties who are essentially looking to share information, sometimes through a third party for data analytics and other kinds of quality improvement and other kinds of similar programs. As a premise and as a first note to write down, don't forget, at a minimum, don't forget HIPAA in all of this. I experienced that, a lot of organizations are going down the ACO route and they feel automatically that this is some sort of separate blessing to a carte blanche free-for-all of data across the entire ACO, and it's just not the case. The ACO, given the Medicare ACO rule, does not throw HIPAA out the window. And then even more so when you're talking about any kind of private payer ACOs, which are not necessarily stood up by any federal law, and depending on what state you are, may or may not be stood up or bolstered by any kind of state law for ACOs, whether that be Medicaid or otherwise. The default really still needs to be, you need to look at the parties who are involved. What is their relationship to one another? Is there a third party that's acting as an ACO that is engaging in healthcare operations on behalf of multiple providers? Are providers exchanging information with each other for the benefit of a patient? Is there a care coordinator involved, and who does the care coordinator represent? Does the care coordinator represent as providing treatment services on behalf of the providers, or is it providing some other kind of service on behalf of a payer? What hat is that care coordinator wearing? You have to ask all these questions: who's involved? Where's the data coming from? When it leaves point A and goes to point B, what kind of disclosure is it? Is it a treatment disclosure? Is it a payment disclosure? Is it a healthcare operation disclosure? And do we have the proper documentation, i.e. business associate agreements in place, or can that kind of disclosure even happen without patient consent? So don't throw HIPAA out the window. Ask who is involved, where is the data originating, why is it being released, for what purpose, and can the disclosure occur without a consent? And if it can occur without a consent, do we have BAAs or other documentation, data use agreements, or whatever the case may be, to support that kind of data exchange in the ACO context? So yeah, that's the biggest thing right here is don't throw everything we've learned from HIE out the window. It's equally applicable to the ACO context.
Very good, very good. All right, this is going to be an interesting one. Let's start with you, Steve. And what to you was the most interesting and impactful recent HIE-related legal decision?
Well, I think both Helen and I are going to be talking about similar types of cases, but I'm going to just mention one that's called the Office of Civil Rights versus Lincare. That's Lincare. And Lincare is a medical equipment and respiratory care and infusion company. And interestingly, unlike most of the ones and the examples I gave about how important encryption is, this shows that even in the old-fashioned paper world, you can still run afoul of HIPAA. And this was just from January, so just a few months ago. And OCR ended up fining this company $240,000. Which is a lot of money because this is, not a gigantic, international corporation or something. So there's been a common theme over the last couple of years where OCR is fining huge amounts of money, big fines for organizations. And what this company did was they allowed an employee to remove paper records that had PHI, and she left them in her car. I mean, there's got to be a great backstory here because in the opinion, it talked about the employee's husband, I don't know if it's now her ex-husband or not, who apparently was the main witness against the company, in this hearing. And he said that he had access to all these papers from his wife's company, and there were, and he wasn't related, and he had no right to see them. But it applies equally to the use of handheld devices or laptops or smartphones or anything that if you don't have the appropriate physical and technical standards, policies and procedures, training, monitoring, then you're going to get in trouble. And what the judge in that case said is that Lincare did not reasonably safeguard the PHI of its clients as required by HIPAA, which allowed an unauthorized individual to access that information. And he also found that they failed to develop or implement policies and procedures to protect PHI from disclosure. So they didn't have any policies, they didn't have any procedures, they didn't train their employees that you can't do this. And I always tell clients, too, that training is not a one-time thing for new employees. I mean, it's got to be ongoing. Every year at least, you've got to constantly train employees what HIPAA is all about and the importance of protecting PHI. So I think that case, just because it's recent, I thought is something that, reinforces that point.
Excellent.
Helen, I think you had a case you wanted to talk about. So.
Yeah, I do. So I also am going to talk real briefly about actually two cases that actually stand for the underlying premise of a parent organization and or an affiliated organization that holds itself out as the umbrella, question mark, what is affiliated entities, is responsible for the HIPAA compliance of all of its subsidiaries and or all of its affiliated entities. When I read these two cases, it sent a chill down my spine. I had the opportunity about a month ago. The New Jersey Hospital Association hosted a meet and greet with Jocelyn Samuels, which is the director of OCR for HIPAA compliance in DC. She came to the Hospital Association, as well as her colleague Linda Colin, who is the regional manager for the Eastern Caribbean region, which covers New Jersey, New York, as well as the Caribbean region. And Linda Colin was responsible for issuing the opinion called Triple S Management Corporation. Triple S was basically a holding company for health plans across the United States. It was positioned in Puerto Rico. It ended up paying $3.5 million because essentially, at the crux of this, the holding company was held responsible for failing to ensure and to be accountable and make sure all of its subsidiaries were in full HIPAA compliance. The finding by Linda Colin and her team for the Eastern region was that numbers of its subsidiary health plans were severely defunct and lacking in their HIPAA compliance programs. And they determined that essentially, ultimately, it was the holding company and the parent of all those subsidiaries that the buck stopped with them in the tune of $3.5 million for all of those shortcomings. So the lesson from there is obviously the parent company in any of your organizations, specifically large healthcare systems with multiple tentacles and subsidiaries, would need to be ultimately responsible for ensuring, taking active steps to ensure that its subsidiaries are fully compliant with HIPAA, and that's what the Triple S case stands for. That came down November last year, at the end of last year, November 30th, 2015, and right after that, it was followed by another opinion, which I think is even scarier, which I've actually asked Jocelyn to get back and issue some further guidance on this. And why this is scarier is, while I can kind of get my head around a parent being responsible for its corporate subsidiary as a parent company, what this other case of University of Washington Medicine stood for, which they ended up paying in the tune of $750,000, is that they also failed to, quote unquote, ensure that all of its affiliated entities were HIPAA compliant. Now, there is a defined term under HIPAA for affiliated covered entities. There's some form of designation that happens, but because these settlement agreements are somewhat light in detailed facts, it was unclear, other than getting a list of a whole bunch of separate kind of entities that seem to have nothing to do with the University of Washington, other than perhaps being somehow loosely affiliated with them. It's just simply unclear what the nature and the crux and the nexus of that affiliation was, and what exactly they did to, quote unquote, designate those entities as their affiliated entities. Is it actual a paper designation? Is it holding yourself out to the public? Is it a formal action? And I guess the crux of the really scary question is, is it something less formal than that can somehow trigger an organization who is affiliated with other organizations to be responsible for those affiliated entities? You can see the implications of this, and I've been starting to advise my clients that, for those who are not your subsidiaries, but you have integrated affiliations with, begin taking active steps to, make it clear that we are separate entities, that we are affiliated for business purposes, but not for HIPAA compliance purposes, to make sure that nobody finds you responsible for the HIPAA compliance of your affiliated or your companies that you're dealing with, or practices that you're dealing with, or labs that you're dealing with that are that you feel should be truly responsible for their own HIPAA compliance. Very scary. And of course, if we get any further guidance from OCR along those lines, definitely look for that on my blog to get some further guidance along those lines, because I think that the opinion leaves grave implications for healthcare systems and the organizations that they deal with in general day-to-day business functions.
All right, let me ask you, let's get this one audience question in very quickly and see if you have any comments. Any thoughts on additional concerns providers should be aware of when deploying a telemedicine application? Either one of you have any thoughts on that?
Well, one thing that does come into play, not only with telemedicine, but just with remote hosting and with a lot of outsourcing, is where is the data going? Is for instance, with telemedicine, we probably all read the articles that said over the last few years that they were using physicians in India to read radiology reports, for instance. So that would be an example where that might be fine, but what kind of HIPAA protections are there once that data goes outside of the United States, or even if it's accessed by physicians or any individuals outside of the United States? And in almost every contract I do now, when I have a warranty that says the data will remain in the United States and it won't be accessed, many of these larger vendors say, well, you know what, we can't sign it as written because we do have a group that handles support, and they're in the Philippines, or they're in India, or they're somewhere else out of the country, and we have to then really drill down and look at that to see what kind of HIPAA protection we have if these other people who are not subject to U.S. laws necessarily have access to the data. I don't know if you have any thoughts on that.
Yeah, I think that's a great point. Very, very pertinent, and definitely because of the context of telemedicine, I think that's definitely a high one on the list to keep in mind. The other two things I guess that came to mind on this point is, number one, I've dealt with a number of telemedicine kind of companies that are sending not necessarily PHI, but biometric kind of information, and I've gotten the question a lot of times whether heartbeats are PHI, or whether radiology reports without any names are PHI, and so on and so forth, since they are quote unquote not necessarily identifiable. But I've always recommended that you do treat it. There is in the de-identification definition, there's a catch-all of any unique characteristic, and I don't want to get into an argument or fall on the short side of the argument of heart rhythms and radiology images are not unique characteristics. So I would say treat everything that's going through telemedicine as if it were PHI. Of course, that triggers all the encryption and everything else, all those kinds of standards. And also, I would also just bear in mind that, HIPAA has the standard of ensuring that information in PHI retains its integrity and is accurate. And so if there are medical devices that are generating the information that's transmitted through telemedicine, of course, we know that the FDA is getting into the regulation of medical devices that transmit information. And so making sure that, you're compliant with not only HIPAA, but FDA in terms of the medical device compliance, which in turn also would indirectly or directly impact potentially the integrity or the accuracy of the data that is transmitted. So.
All right. Well, unfortunately, we have some questions coming in, but we're just about out of time today. So hopefully next time our audience can get them in a little sooner. So that's about all the time we had for this event today. I want to ask everyone to please take a minute and answer the post-event survey, which will pop up when you close out your screen. I want to thank our panelists, Helen Ostaslawski and Steve Fox, for joining us and all the research they've done and prep and the great information. We appreciate it. As I mentioned, you'll receive an email when our archive has been posted to our YouTube channel. And for those of you who have the CHIME CHCIO certification, attending our webinars gets you 1 CEU for each event. So let CHIME know you were here, unless you've asked us to do so, and we will. Sponsorship opportunities, contact Nancy Wilcox. Certificate of attendance is the final slide for those of you who are getting CEUs from other programs. And you can go to our website to view our upcoming schedule. So again, I want to thank Helen, Steve, and our audience, and everybody have a wonderful day. Thank you.
Thanks very much.